morning. So as Tamsin said, I will cover joint employer status briefly. It's a topic that may not be as exciting as some of the others here, but it's very important because of the substantial consequences that can arise if joint employer status applies to you. So next slide, please. So the question is, what is joint employer status? It applies when, for purposes of minimum wage and overtime requirements, the Department of Labor, both at the federal and state level, will consider two different companies to be a worker's employer for the same work that gets performed. So as an example, a joint employer relationship could exist where a hotel contracts with a staffing agency to provide cleaning staff, but the hotel directly controls what the cleaning staff does. They cut their paychecks, they tell them which rooms to clean, they tell them where to go. If the agency and the hotel are joint employers, then they both become responsible for worker protections. And this doctrine determines the scope of employer liability in a lot of different settings, including franchise relationships, independent contractors, and contingent workers. There are two general types of joint employment. The first is vertical joint employment, which is the example I just gave. It's when a worker is employed by one employer, but is actually economically dependent on another employer above them that receives the benefit of the worker's labor. And that's what we typically see. There's also horizontal joint employment, which is a little less common, but we see it more often in franchise relationships, which is where two or more entities employ the same worker for separate hours within the same work week. So an example of this could be if you have an employee at a McDonald's, they pick up 3 shifts at one location, they pick up 2 shifts at another location. Both McDonald's franchises are considered a joint employer, depending on how the analysis falls. The main takeaway with this is that under both the Fair Labor Standards Act at the federal level and the Massachusetts Wage Act, there are substantial financial consequences if you are analyzed to be a joint employer and you fail to pay compensation, you misclassify an employee, or you engage in unfair labor practices. So as I said, it's very important to understand whether or not it applies to you. Next slide, please. Over the past decade in particular, there's been a lot of back and forth as to what a joint employer is under federal law, which is the primary body of law that governs when it applies. For a long time, the National Labor Relations Board, which is a quasi-judicial agency at the federal level, has issued decisions as to what a joint employer is, how to analyze it under the Fair Labor Standards Act. But the Trump administration, briefly before Donald Trump left office, went through a proposed rulemaking to pass what's called the Joint Employer Rule, which was on the books for about 1.5 years. And this was published in the Code of Federal Regulations. It was a rule that outlined a set of factors that you see here, 4 rigid factors that are to be applied to determine whether or not there is a vertical joint employment relationship. The touchstone of this analysis was whether or not an entity exercised actual or actually exercised control over the employee. Not whether they could or whether they had the power to, but whether they actually did. And courts were only supposed to consider factors outside of these 4 if they led to the same point. In other words, if they showed whether or not a potential joint employer exercised significant control over the terms and conditions of the employee's work. Considering an employee's economic dependence on a potential joint employer was explicitly prohibited. And as for horizontal joint employment, the rule didn't really change much. The analysis was then and is now and has been, if employers are sufficiently associated with respect to employment of the employee, then they may be considered horizontal joint employers, and they'll have to aggregate the number of hours worked in order to determine compliance with the FLSA. Next slide, please. Now, as with a lot of policies for Donald Trump's administration, there was significant pushback shortly after this rule was passed and put on the books. 17 states and the District of Columbia filed suit against the Trump Department of Labor in the Southern District of New York, and the court ended up vacating substantial portions of the rule for the 3 general reasons that I've outlined here. The court found that it was impermissibly narrow because it focused so closely on actual exercise of control, rather than the suffer or permit to work approach that the Fair Labor Standards Act takes and the Department of Labor had taken before. It also looked only at the definition of employer as opposed to the definitions of employee and employ, which are found in other places in the Act. It was novel in that it disagreed with past Department of Labor understanding of how to apply the analysis. And it was nebulous because it didn't adequately consider the cost to workers if the number of joint employers decreased as a result of the rule. Also, the test for whether an entity was the primary employer was entirely different from the test of whether you were a joint employer, which could lead to inconsistent application. Next slide, please. But in the end, as has been the case with joint employer status throughout the years, the court's determination and decision ultimately became moot because the Biden administration, once Joe Biden came into office, wiped the JER off the books in its entirety and took away the rule for many of the same reasons that the court did. It was inconsistent with past guidance. It was an inaccurate interpretation of the FLSA, and it had a too narrow focus on employer control, which was contrary to pre-existing federal court analysis. Again, it also didn't adequately consider the impact on employees. The Biden Department of Labor was particularly concerned with the impact of the rule on women and people of color and agricultural workers, people who tend to work with staffing agencies more frequently than other demographics. And the Biden Department of Labor also looked at the business community to determine, well, what would be the real impact of taking away the rule? And it didn't find that there would be any impact on the business community, despite concerns that popped up by businesses during the rulemaking process, because many courts didn't end up taking the joint employer rules factors into consideration when doing their own analysis. They continued to go their own way as they had before. Next slide, please. So that leaves us with where we are now and where to go next. Well, where we are now is that we're basically back to there is no rule. There is a disjointed analysis by federal courts and state courts across the country that tend to apply their own what are called totality of circumstances analyses. The scope of vertical joint employment is, again, a lot wider. If a worker is formally employed by your business, meaning that you have the ability to make decisions concerning that individual, even if you don't actually do so, you may be considered a joint employer under the vertical joint employment analysis. As for horizontal joint employment, the question you have to be concerned with is, do two employers together control the employee's services, what that employee does, either by contract or from a practical perspective, from Monday to Friday or from a typical work week as it applies to your business. Federal and state courts, so long as they stick within these bounds, will get to consider their own set of factors under a totality of the circumstances analysis, as they had done prior to the joint employer rules passage. The federal government, at least from Biden's Department of Labor, has said that it's going to stay relatively silent in passing rules in the future. Its approach is going to be to look at the text of the FLSA and determine whether or not you are a joint employer under the exact text as it sees it before considering whether or not to go down the route of proposed rulemaking again. So the reality here is that this is a political animal, this doctrine. It will change from administration to administration, from party to party. So it's important to keep an eye out when new administrations come into office, which we may be facing in 2 years, and to make sure that you stay updated when courts in your jurisdiction come out with rules. And of course, we will continue to update with changes as well.